Welcome to the Judicial Decision-Making Panel. I am Kathleen Wood. I'm a staff attorney with the Animal Legal Defense Fund. Thank you so much for joining us. Before we get started, I would like to thank our gold sponsor, Chapman, Kubine, Allen, and Hoosie. This session will include pre-recorded presentations followed by a live Q&A with our panelists. Now I'd like to introduce our panelists. First up, we have Judge John Romero, who serves in the New Mexico 2nd Judicial District Court in the Children's Court Division, where he handles cases concerning delinquency, child welfare, and adoptions. His court is a juvenile detention alternatives initiative model site. He is also co-chair emeritus of New Mexico's Children's Court Improvement Commission, is the former board president of the National Council of Juvenile and Family Court Judges, has served as lead faculty on the National Judicial Institute on Domestic Child Sex Trafficking, and is a member of the National Advisory Committee on the Sex Trafficking of Children and Youth in the United States. He was the first judge in the country to be recognized as a certified child welfare law specialist by the National Association of Counsel for Children. Second, we have Judge Gail Raisin, who served on Baltimore City Trials Court for more than 20 years and currently presides over the Mental Health Court in the Circuit Court for Baltimore City as senior judge. She served on the Baltimore City Mayor's Anti-Animal Abuse Advisory Commission. She has created judicial training programs on animal cruelty and has lectured at the annual Animal Cruelty Conference of the Association of Prosecuting Attorneys. In 2019, she was a fellow at the Harvard Law School Animal Law and Policy program, where she wrote a guide for trial judges on the subject of animal hoarding. Finally, we have Jamie Contreras, who graduated from Lewis and Clark Law School in 2002, where she was a member of the Animal Law Review and received a certificate in environmental law. After graduation, she clerked for the Oregon Court of Appeals before moving to the Oregon Department of Justice, where she worked for nearly 15 years, primarily in the appellate division. There, she successfully represented the state of Oregon in two groundbreaking animal law cases before the Oregon Supreme Court, State v. Nix and State v. Newcomb. She then worked as a senior staff attorney with the Animal Legal Defense Fund's Criminal Justice Program. Unfortunately, Jamie was unable to join us for the live Q&A portion today, so I will be answering any questions that you might have regarding her presentation. Before we get into the session, I wanted to share a bit about the Animal Legal Defense Fund's partnership with the National Council of Juvenile and Family Court Judges. We first joined forces with NCJ-FCJ 2 years ago and have assisted them in publishing a resolution officially recognizing the link between animal cruelty and interpersonal violence, as well as a bench book for juvenile and family court judges exploring animal cruelty issues, both of which are available in this panel's resources. The Animal Legal Defense Fund and NCJ-FCJ have also been working on creating a series of webinars to educate judicial officers and other stakeholders on the link between animal cruelty and child abuse, juvenile delinquency, domestic violence, and elder abuse. With that, I will turn things over to Judge Romero, the former president of NCJ-FCJ.
Welcome to this presentation regarding the link, what judges and other court personnel need to know about animal cruelty issues. We clearly are in a changing climate and specifically how it impacts on animals in our homes, in the community that we live in. But that changing climate directly impacts how we work in juvenile and family courts, how we deal with the families that touch our cases and are part of our cases. And as you can see from some of the slides on there, you know, we're doing court much differently, which limits our access to important information. Virtual court is not everything it's cracked up to be, but it's the best we can do in most jurisdictions, and also balance that against protecting public health. Our kids as well are in a different climate with school starting back and kids and families deciding about whether they actually go into the courtroom or not. Kids are studying from home, attending classes from home, which also limits the access that courts and others have to what may be going on in the household. You can see some of the other things that are different climate. Even all of us who may need medical treatment or medical assistance, we're very often doing that by video, again, through telehealth or video health. Many of us are working from home, and that also brings about a different climate in which we have access to a lot of information, but we're limited in the information that we get that impact our families and the animals that live with us. Family isolation may sum it all up. in that we don't see the families in our courtroom anymore. The veterinarians very often don't see them in their offices. They pick the animal up from the car and bring that pet in to treat them and then take them back out. So that interaction, that ability to get that subtle information or ask the questions that need to be asked in this changing climate is much more limited than it used to be. So I have a couple of questions up on the screen. I'd like you to take a look at those, and while we can't interact personally, if you would enter your answers in the chat box on the right hand of the screen, and we'll take a look at those answers from all of you later on in the presentation. As a result of this presentation, we're all going to have a better understanding of the link between animal cruelty and the 4 areas that we typically deal with in juvenile and family courts: domestic violence, child abuse, juvenile justice, often referred to as delinquency, and elder abuse cases. As a result of this presentation, we're all going to learn a little bit more about what judges and other court personnel can do in court and out of court to be more aware of what's going on with our families, to safeguard those family members, and also, very importantly, to safeguard the animals that we are all attached to as our pets and family members. Finally, we're going to learn about resources that are available and tools that are available for judicial decision making and for leadership on the issues of animal cruelty and the links to the 4 areas that I talked about just a moment ago. Based on some of the answers in the chat box, it's easy to conclude that many of us place a high value on our pets and the animals that are in the lives of children and families. I won't read the bullet points, but you can see for yourself that it's not unusual for families to have a pet in the household. What I found striking the first time I heard this was that that second bullet point, and we see that in our cases where fathers very often are missing from what's going on in the case. Maybe mom's partner, who is not the child's father, is part of the dilemma that's going on. Again, when I first was asked the question, do you consider your pet a family member or just another animal? And I think I was in the majority of those who say, well, they're not really just animals. They're our family members. And quite frankly, if you have cats, they train you, not the other way around. The last bullet point, I think, is very significant in the work that we do in juvenile and family court. We hear so many parents and especially kids say, he or she is always there for me, no matter what. Kids tend to look at their pets, even above their own parents and their friends from school or wherever they may have friends, as always being there for them, no matter what happens. Even if we get angry at each other or I yell at them, they're always going to be my friend, my family member, and they'll always be there for me. Very simply stated, this presentation could be summed up on this slide. When animals are abused, people are at risk. When people are abused, animals are at risk. We're inextricably intertwined with our family members, our animals, those that live in our household with us. The significance of this is this can all be a sign of a red flag flapping in the breeze of what we need to look at when we're interacting in court in whatever type of case we're doing, to not just ask about the people, but also ask about the animals. Similarly, animal control folks in our city governments, veterinarians, if they see an animal that's being harmed or abused, that it's logical. It should be a knee-jerk response to say, how are the kids or how are the other family members doing? Interpersonal violence, family violence, is unfortunately very common in our world today. Animal cruelty necessarily is interconnected with family and interpersonal violence. Animal cruelty by itself not only is a safety issue, it's also a public health issue. Why? Well, because it concerns very broadly violence against vulnerable members of our society, not just people, but animals as well. Some other data points that are up here are some statements that are based on research and studies. Those who abuse animals tend to be more likely to also hurt people. Federal agencies have done much of the studying as well, and you can see the bullet points for yourself, the relationship between animal abuse and crimes against people, property crimes, and even substance use and other unacceptable behavior in the community. Domestic violence and animal cruelty. I don't know how often we think about the connection between those, but they're inextricably intertwined with each other. The presence of a pet in the home has an impact on the kids and the abused adult in terms of deciding how they're going to deal with their situation. Are they going to leave? Where are they going to go? And if so, what's going to happen to the pet if the pet doesn't go with them or if the pet stays behind? We've learned from many decades of dealing with domestic violence that the time of leaving is one of the most lethal times in the lives of those who are abused and mistreated in the home. But one of these studies stated that that decision was not just about where you're going and are the kids going to go with you and how are you going to survive financially, but also what's going to happen to my animal, to my pet, to my family member. And those victims of domestic violence, kids and adults as well, report that that pet is very often used as a pawn in the perpetrator's skill set to manipulate and control those who are being harmed. The last bullet point is one I'd like to invite your attention to as well, and that if you're an animal abuser, you're very likely more dangerous as a batterer than batterers who don't abuse animals. In my world, I deal a lot with child abuse and neglect, along with juvenile justice. So, how do the acts of animal cruelty against a pet affect the children that are connected to those pets? As I mentioned earlier, they're very often looked at as already noted, more of my friend and more of my family member than my own parents or my own siblings are. What about a kid that's abusing an animal? Should they be criminalized and prosecuted because they're being cruel to an animal? Should we ask an additional question? If a child is doing this, have they experienced abuse, and are they victims of someone's battering efforts? Here are some more bullet points to talk about the specific link between child abuse and neglect and those who harm or hurt animals. Children in the home who, and adults as well, who have a pet, that may be the comforting factor that they have when they're living in an environment of violence and abuse. But that connection can also be a dangerous one. We hear a lot in our neglect and abuse cases about children who jump in to help mom, usually mom, who's being beat up by either dad or a significant other, and they themselves get hurt. That can happen also when the batterer or the abuser is hurting an animal, and that animal is very close to and connected to the child. When they jump in to help the animal, that they themselves get hurt. When an animal is being abused or hurt, as already noted, others in the home may not be safe either, including the children who are connected to those animals, to their family members that have fur on them. There used to be an excuse for batterers who would say, well, I didn't hit the kids were not harmed, but they witnessed the abuse of another loved one in the home. That's abuse as well, and it's traumatizing to children. Similarly, when a pet is being abused and a child witnesses that abuse, it creates all kinds of trauma, and that impacts the child not just then, but into the future. As court professionals, when we make a decision to remove a child from a home and place them in foster care, in stranger care, as opposed to being placed with a family member, that's very traumatic. Very often that separation involves separation not just from the adults in your home, the parents, but also from your siblings. If you're being separated from a pet and placed in foster care, that just adds to the trauma and the feelings of despair and of lack of connection to anyone. Juveniles in our juvenile justice cases often get criminalized because of their behaviors. Everything from fire starting to vandalism to graffiti, all of those kinds of things. They're also criminalized when they may be charged with abuse of an animal. But if a child is abusing an animal, does that necessarily mean that they're going to be violent against people in the future? Bullying is another issue that's talked a lot, usually in the school context, and very rarely in the school context do we talk about um, uh, students who may be harming an animal. Very often, those teachers and school administrators rarely ever ask or think about that connection. The studies have shown that just because a kid is violent against an animal, that's not a predictor that that child will be someone who shoots or harms or otherwise inflicts damage on other human beings. It may be an indicator, however, that that child, as already noted, is abused themselves, that they may have an oppositional defiant disorder, conduct disorder, or any other diagnoses that may come about. And as a judge, I certainly am not an expert in that. I would hasten to add that most attorneys are trained in the law, not in youth development or in psychological aspects of kids. But that's when we together as a team ought to consider whether there is an assessment that needs to be done, and if so, order it. And based on what the results of that assessment are, should treatment, other therapy be involved to help that child with what is really the issue, not what appears on the surface as being an animal abuser, although that's important, but there may be other underlying issues that lead to that behavior. Talked a little bit earlier about bullying and how that's an issue in school, and yet to the extent that vandalism, fire setting, graffiti are all indicators of potential delinquent behavior, animal abuse starts much earlier in a kid's life than those other indicators of possible offending behavior by juveniles. There's some concern about kids who may actually may get excitement out of hurting animals. That's a totally different issue that needs to be dealt with, and may in fact be a predictor of extreme violence in the future. Again, an assessment, a screening, assessment, and perhaps an evaluation may be in order for that youth who is demonstrating that behavior. What about elder abuse and animal cruelty? This is a country that is growing grayer, like yours truly, and I am in the majority of folks in our population in that we are a graying population. The baby boomers are coming of age. We sometimes require the help of a caregiver. That caregiver may resent having to take care of us, or maybe they're getting paid to take care of us, but they're not happy with their situation. And those of us who require that kind of assistance may be very vulnerable to abuse from our caregivers. If that's the case, if I have an animal in my home, our 2 cats, for example, then they may be at risk of abuse as well. The folks who work in assisting adults, adult protective services workers, for example, they very often hear from the folks that they're serving that their animal, their pet, has been mistreated by the adult caregiver. Not just mistreated, but even injured or threatened or otherwise just neglected and denied care by that caregiver. I'm here to take care of you, not your dog or your cat. Elders who themselves are incapable of taking care of their basic needs and don't have a caregiver may neglect the needs of their pet, even something as basic as feeding them, as making sure they have clean water, because they're not even able to take care of themselves. So neglect of an animal is by an elder is very often related to their own self-neglect because of their own incapacities. So the question you might be asking, and certainly a question that I've asked when I first heard about animal abuse, was, well, what can I do? I'm just here to call balls and strikes, which I don't know too many judges who deal in child welfare, juvenile justice, or domestic relations as being just calling balls and strikes. We've been accused of being social workers, in fact, instead of legal professionals. But there are things that all of us can do as lawyers, as judges, as social workers to ensure that pets and family members are kept safe. So just an example, on the bench, when we actually have a hearing and we're on the record, there are certain things we can do. In a domestic violence case, many of the judges in our family court do not hesitate to include animals in a safety plan or in an order of protection. As a judge dealing with child maltreatment or child abuse and neglect cases, I should be asking the question when I read in the initial document that there was dog feces or pets running around the house, or 5 cats in the household, say, to ask the question in that initial hearing, what about the pets? Who's taking care of them? Are they attached to any of the kids in the household before I decide to take the child out of the home and leave the pet behind? When an elder is being mistreated, or their animals are being neglected and mistreated, as a judge and as other court professionals, we can make referrals to services in our community that provide pet care or assist the adult, the elder, with means of assisting not only themselves but that pet, to ensure the pet is not neglected or otherwise abused. I've had a case where the teenage girl made it very clear that she didn't want to visit with her parents. She didn't think very much of them. She did place as a high priority having contact with her dog, and could the dog actually live in the foster home that she's in with her. That's how important that dog was to her. We can come up with creative solutions, judges and attorneys and social workers together, to ensure that that trauma inflicted on a child when they're removed from a family, that is not also exacerbated by being removed by a pet that they may value more than any other human being in their lives. We already talked about assessments, screenings, and leading to an assessment if it's indicated, and then that assessment may require a higher evaluation with recommendations for care and treatment of what's going on with that person who's being traumatized. Off the bench, there are a lot of things to be considered. Animal and pet-related cases don't occur in a vacuum. They may be occurring in a misdemeanor court that is different from the general jurisdiction court. And if we don't communicate with each other, we often do nothing, or we're working at cross purposes with each other. Not just other courts, but other agencies, animal control folks, veterinarians, others who may be coming into contact with the family and their animals. Collaboration, working together, and discussing these various issues are important for us to do. The National Council of Juvenile and Family Court Judges teaches all of us judges from the very beginning that as judges, one of our primary responsibilities is to get folks together and to discuss what may be greater issues. Multidisciplinary meetings. The old saw is, if the judge calls a meeting, people will come, maybe not happily, but we judges don't need to assume that we have to be in control, that we have all the answers. The folks that come together collaborating can come up with great solutions that look to animal shelters, how to protect elders, and how do we really identify foster parents who may be willing to have that child's companion animal, the pet, also in the home with them, or at least have visitation that they facilitate with that animal. We need to be careful not to criminalize or villainize all of those who are engaged in animal cruelty. Oftentimes, they were not taught how to be empathic or how to understand that all life has value. Humane education or empathy courses are available in many communities. In some communities, they're not. Those who may know how to develop those courses should be contacted to help create them. I already talked about multidisciplinary training, cross-disciplinary training, so that all of those of us in the community who come into contact with human beings and animals can discuss how we together may make a difference in addressing this issue that is a problem for all of us who live in this community. In many states, it is a requirement that if you deal with kids and families, you're a mandatory reporter. You have no choice but to make the report to Child Protective Services or to law enforcement or to both. In some jurisdictions, veterinarians and others who provide care specifically to animals are being included and required by state statutes to similarly be mandatory reporters. Many of our courts, like in my jurisdiction, the misdemeanor court is extremely busy with traffic violations, code violations, misdemeanor violations, and the volume of cases they handle is very daunting. However, in my jurisdiction, they are the ones who basically started the ball rolling on dealing with animal abuse issues and how to have a therapeutic court that deals with the abuser and the animal that's being abused and those who are connected to the animal. These are only a few of the resources available. I think if you just click on any of these in the PowerPoint presentation, you will be taken to the site. And of course, being unabashedly shameless, the first one on the list is the National Council's resolution concerning animal cruelty and its link to other forms of abuse that I've talked about. Colorado and the Animal Legal Defense Fund have done a lot of work in bringing this issue to the forefront. As you can see from the PowerPoint presentation, not all of the animals that are shown are kittens and puppies. Large animals are part of this whole spectrum of abuse and mistreatment. In my community, one of the things we're seeing recently is animals who are being starved, horses who are being starved, actually being victims of drive-by shootings. Who would do that is unconscionable to think that there's folks who would do that, but they're out among us, folks. I invite your attention to this particular technical assistance bulletin developed in collaboration and in partnership between the National Council of Juvenile and Family Court Judges and the Animal Legal Defense Fund. The link will take you to the site. It's downloadable for free. And I am told that if you actually want a hard copy, you can request one and it'll be provided to you. A lot has been covered, mostly by way of introduction and to pique your interest. My email address is noted on the very last slide. I'm happy to respond to any questions that may come up based on my presentation. We'll have an opportunity later for questions and answers as well. Thank you all very much for this opportunity to present the judicial perspective, the court perspective on the link between animal abuse and the ways human beings are affected by animal abuse. Thank you.
Greetings from the Eastern Shore, Maryland. I'm sorry I'm not across the Chesapeake Bay with all of you in Baltimore, but we can hope for next year. As you've heard, I've been presiding over a mental health court in the Circuit Court for Baltimore City, a felony mental health court, for at least as long. For over 10 years, I've been interested in the topic of animal cruelty. So last fall, I did a fellowship and wrote a monograph. And because I thought it was a catchy title, I called it The Man Who Married His Pigeon, about one of the more bizarre cases, a lawyer in California who hoarded pigeons. A search warrant of his home resulted in the seizure of over 200 live pigeons and over 100 dead pigeons. One of those pigeons, the live pigeons, he considered to be his wife, Twister. And he was so distraught at losing her that SPCA-LA, after doing a thorough examination for illness and abuse, released her to this lawyer. 4 years later, there was a 911 call. He was in respiratory distress because he had another 100 pigeons in his house, and he died. So it's a topic with a lot of mental health implications. And I prepared for this talk a PowerPoint, but I realized that you are probably at this point very tired of looking at PowerPoints. So I am going to zip through the slides on the PowerPoint. I wish I had a slide that referred you to a website where you can read articles that will teach you everything you ever wanted to know about animal hoarding at the Tufts Vet School. It's tufts.edu/hoarding publications. So I'm going to tell you right now, my attitude towards animal hoarding cases in the criminal justice system. I think animal hoarding is a very complex public health and societal problem. It's kind of like substance use disorder. We have these serious problems, and when our society doesn't know how to solve them, they end up in the criminal justice system, where I'm not sure we are effective. After interviewing many people who work with animal hoarders, they're not sure the criminal justice system is very effective. But when a case comes to court, we don't have any choice. So here's what I have learned, and I'm going to, again, zip through the slides and share with you what it is like to be a judge dealing with people with mental disorders trying to modify their behavior. In this case, animal hoarding behavior. So very quickly, what is animal hoarding? It's basically having too many animals when you can't take care of their basic needs. There's no minimum number. It's not 10, it's not 20. If you have a gazillion dollars and you can take good care of animals and provide them with food, water, sanitation, shelter, enough space, and vet care, you're not a hoarder. But the people who end up in court often starve their animals to death, unfortunately. And it's coupled with a total denial of the inability to provide minimum care and the impact of that, namely disease and too frequently death, and the persistence despite a failure to provide care in accumulating animals. We recognize three categories of hoarders. Overwhelmed caregivers often suffer a change in social, economic, or medical circumstances like loss of job, loss of family member, illness, or disability. But these people are aware of the problem, and rather than deny it, they may minimize it, but they're willing to accept help, to accept care, to accept food and vet care, and often to surrender animals. The focus of what I'm going to be talking about is rescue hoarders who have a very distorted sense of identity, sense of being special, totally deny the problem, believe that the acquisition of great numbers of animals is necessary for those animals to avoid seizure and probably euthanasia by the authorities. They're very secretive and refuse help. The third category, yeah, these people belong in the criminal justice system. They're exploiter hoarders who operate puppy mills, and they're sociopathic. They're doing it for profit. Diane Balkin, recently retired from ALDF, called animal hoarding animal cruelty on steroids, because compared with intentional acts of cruelty such as dogfighting and other acts of violence against animals, many more animals are hurt and die as a result of hoarding. There are no hard numbers, but it's guessed that approximately 250,000 animals are subjected to hoarding annually by all kinds of people. Psychiatrists in Manhattan had 700 cats. Psychiatrists in California hoarded pigs. There's a great book about a woman with 550 dogs who moved along the West Coast to avoid detection. Lawyers, nurses, teachers, college professors, and even vets, the great majority are women, tend to be older, and this behavior is compulsive. Unfortunately, even with the intervention of the criminal justice system, tends to be 100% recidivism. Now, I'm particularly interested in why people hoard animals. What are the mental disorders involved? There actually is a diagnosis of hoarding disorder in the latest Diagnostic and Statistical Manual, DSM-5. I think it's oriented more towards object hoarding, but it does recognize animal hoarding as a subset. One recent study attributed hoarding to anxiety and depression. Animals provide some relief from that. Another major explanation is attachment disorder, and that's a diagnosis that is made often in childhood. It probably goes on undiagnosed with these hoarders, but it involves growing up often in a deprived, emotionally deprived family with the inability to form close attachments with people. Often there's trauma and loss, and sometimes there is a family pet and the person can form an attachment with the pet. This gets worse in adulthood, in which these people end up being isolated, not forming relationships with people, and again turning to animals. Very often these people develop personality disorders, mistrust, paranoia, and so forth. Delusional disorder is one that I am familiar with as a result of the case I have in my mental health court. This is not the kind of delusional disorder that goes with schizophrenia. We're talking about fixed delusional disorder. That's one fixed false belief. I am a rescuer. I am a savior of animals. I have special powers of communicating with animals. And I am very special. It approaches grandiosity. And it is a belief that cannot be displaced despite the evidence. For decades now, as a judge, I have been talking to mentally ill criminal defendants. And the most difficult people to deal with are those who do not believe they're mentally ill, and in particular, those who suffered from a fixed delusion. You just can't argue with them. So that's why I say the task of a judge is to focus on modifying behavior, not to convince a hoarder that he or she doesn't love animals. Forget that, but to change the behavior, to control the behavior. And that leads me finally to pathological altruism. And this goes back to the grandiosity that hoarders, in order perhaps to forge an identity, they need to believe they love the animals and the animals love them back, and that they are fulfilling their needs, despite the evidence of the starved animals in their homes, the carcasses, the lack of food. Clearly, this is not love. It is satisfying the psychological needs of the hoarder. And so this term has been applied to rescue hoarders. This behavior is a crime in every state, although only a few states have a designation of animal hoarding. If a person ends up in the criminal justice system, despite all efforts by local animal control agencies and other people to help them change their behavior, there are pretrial issues for a judge to deal with, and there are very few judges who actually ever get these cases. So it's a big challenge deciding what to do with the animals that have been seized, litigation of search warrant issues, perhaps a pretrial civil forfeiture case, deciding how to deal with the animals themselves as evidence. And the way I have encountered animal hoarding most recently, again, is in my mental health court, in which a defense attorney raised the issue of competency. Anyone in a case can raise competency: defense attorney, prosecutor, judge, because a defendant constitutionally must be competent to stand trial. But if a person, due to mental disorder, doesn't have a rational understanding of the nature of the proceedings, or in my case, cannot assist counsel, that person may be adjudicated incompetent. Again, in my situation, the defendant cannot cooperate with his lawyer. He's tried to fire him. He's made complaints about him. He thinks I'm in a conspiracy with him. He writes me letters regularly accusing me of corruption. And after I admitted him to the state forensic hospital for treatment. He is absconded, that is, escaped twice, and he is on the lam. Another pretrial issue that could be raised is a plea of not criminally responsible. That is, a defendant saying due to a mental disorder, he cannot comply with the requirements of law or can't appreciate the criminality of his conduct. As applicable as that plea might be, you're not going to see it because the defendants who are hoarders do not believe they're mentally ill. Trial of an animal hoarding case is very difficult, in part because of the issue of the mental disorder and personality disorders that accompany that. Lawyers get fired all the time by their clients. It's very difficult to deal with a client representing herself. Courtroom management is a terrible problem for a judge and requires great patience. And then there are other issues, sometimes involving experts and violations of pretrial conditions of release. But here's what I want to get to and how I want to spend the rest of my time. Sentencing. I've already mentioned that while most state statutes require pretrial psychiatric evaluations and some states require mental health treatment at the defendant's expense, there are all kinds of problems with both the evaluation and treatment. First of all, mental health evaluations usually depend upon the history giving of the defendant. Psychiatrists, psychologists, evaluators do not conduct independent investigations. You just hear the defendant's side. They may see the charging document. So it's really important that as much information as possible be given to the evaluator, the facts of the case, maybe some video from the trial for the evaluator to get an understanding of the defendant. So in ordering mental health treatment, there's a problem for anybody who wants access to mental health treatment, but in particular for these defendants. They have to execute releases to the provider so the providers can report back to the court. That's an issue. Probably the biggest issue is an animal ban, either total or partial. Some states now, I believe, mandate animal bans, but there is a dispute among experts about whether a ban should be complete, that is, no animals, or partial, having a few. Those who believe this behavior is truly compulsive think that it's a mistake to let somebody who's a hoarder have any animals. Others, looking more at the defendant's emotional state, would argue that, as with the man who married his pigeon, not being allowed to have any animals causes so much distress, and because the defendant's identity is caught up in relating to an animal, that it's better to let the defendant have an animal or two. Now, enforcement is a real problem. Somebody's got to go out to the defendant's home and look for animals. And so you've got to have either the probation department doing it or animal control doing it and reporting it back to the court. Now, advocates and other people involved are often very unhappy with judges about not sending these people to jail. And in a recent case in Maryland, a judge was dealing with an elderly woman who had 100 starving horses on her property. And she just said, if I thought it would do any good to send you to jail, I would. But she recognized, number one, she wouldn't. Number two, the trend in the criminal justice system is to keep people out of jail through diversion or through treatment. And so I think by now most prosecutors accept the fact that, at least on the first go round, these people are not going to go to jail. And again, it's a problem because there's no validated treatment for animal hoarding. So what I propose is the approach I use in my mental health court, which is a problem-solving court. You use a team. the judge. The judge has got to be the captain of the team, I guess, but you need the lawyers. You need a probation agent who's really going to be responsible and engaged. Perhaps your animal control agency, if they're expected to help out with the inspections. You need the mental health provider who, with appropriate releases, is willing to report to the court. And if your jurisdiction has a local animal cruelty task force, you might even engage somebody from there. As with drug court and mental health court and a veterans court, all problem-solving courts, frequent status conferences are important. Bring everybody into court, bring the defendant into court, and have the probation agent report on compliance with all probation conditions, including the mental health treatment and including the home visits. This is a big challenge. And again, the track record for animal hoarding and hoarders is one of recidivism. But I believe, and this has been borne out in other problem-solving courts, establishing a relationship between a defendant and a judge, believe it or not, can actually enhance compliance. Again, I call it the jurisprudence of relationships. And these people have not had relationships, meaningful relationships. And maybe this kind of therapeutic approach can provide a chance for one. Thank you very much, and I'd be happy to answer any of your questions.
Good afternoon, everyone. I'm Jamie Contreras, and it is such an honor and a pleasure to be here with you virtually today. There are so many of you that I want to meet in person, but that's not in the cards this year. But it is an honor and a pleasure to be presenting to you from my office with my snoring dog at my side and my cats, who will probably come in and out of the room. So please bear with them and with me, and I hope I get the chance to meet all of you in person sometime soon. So I am the non-judicial participant on a judicial decision-making panel. And you've heard from the judges already. Now it's my turn to talk to you from an advocate's perspective about my experiences with persuading judges and what I've found to be effective. My background is from Oregon. All of my practice up until December of last year, when I made the jump to the Animal Legal Defense Fund, has been in the Oregon appellate courts. So that's my frame of reference. That is the beautiful stained glass ceiling of the Oregon Supreme Court that you're seeing there. I spent more than a decade practicing in Oregon's appellate courts, and before I started my practice with the Oregon Department of Justice, I was a judicial clerk. So I had the opportunity to see judicial decision making from that perspective as well, which was very helpful to get an insider's view of just how things are done and how judges, what they find compelling, what they find persuasive. My background is primarily in criminal law, but not exclusively so. And I was lucky to have the opportunity to represent the state of Oregon in a couple of key animal law cases. I was lucky to practice in a progressive state with strong animal laws and a court that was willing to hear my arguments and give them consideration. I also give myself some credit for having learned through experience and watching a lot of lawyers and a lot of judges in action, how to present my arguments in a way that judges found compelling and were receptive to. So my plan today is to be sharing some strategies and tips for persuading judges that I've learned during my practice and through observation, trial, and error. Now, my experiences in the appellate court, but I think all of the same lessons are true when you're talking about persuading a trial judge, when you're making a legal argument in the trial court. So it's not specific to criminal law, it's not specific to appellate law, it's just good advocacy when you're talking about making legal arguments. Juries are outside my experience and outside my purview, so I don't make any representations about knowing how to persuade a jury. And I should note that I'm speaking from my personal experience when I was an attorney with the Oregon Department of Justice, and not on behalf of the Animal Legal Defense Fund as an organization. So on to the substance of the presentation, which is the next slide. credibility and integrity are everything. I think lawyers know this, you know this, but it doesn't, you can't hear it enough, and it really, really does matter. Once you lose your credibility, once your integrity is called into question, you may never get it back. And so it's something that you have to guard with everything that you have. Always be candid. That people who think that they're pulling a fast one by not citing a case, the court will find out. The court will learn the truth, and if you didn't direct it to them, your credibility and your reputation are going to take a hit. Demonstrating good character also makes your argument more persuasive. In addition to just making you a good person, it makes you a more persuasive advocate. The law review article that I submitted along with my presentation, there's a quote in there from Aristotle, and I thought was particularly, it really struck a chord with me, and that's, we believe good men more fully and more readily than others. So if the court sees you as a good person, a person with good character, they're going to be more likely to listen to you and to give your argument credence. Your reputation matters. Treat everyone well. Now that I've been practicing for coming on 20 years, you learn how small the legal community is. You run into the same people you went to law school with, people you used to practice with. And your colleagues and classmates may be on the bench someday. That's happened to me a few times now, and it's a bit of a shock, but it happens. So you have to cultivate your reputation with people on the other side of the aisle, with people that you interact with every day. It's essential to your reputation and your eventual persuasive power as an advocate. It's important to do the right thing even when it hurts. For me, that I had a moment of reckoning with State versus Nix. It's a case that I represented, the state of Oregon. It's an important animal criminal law case. You may be familiar with it, and you might see a red flag when you pull up that case in Westlaw. You see that there's a red flag associated with it. And the reason that happened is I was in a position of having realized after the opinion issued that we had a jurisdictional problem, that the state shouldn't have been able to bring the appeal. The defendant hadn't raised it, but I caught it. I knew that I had to do the right thing, even though it was incredibly painful. It's a case I cared a lot about, and it's a case that was a really important one. But it was my obligation as an officer of the court, and for my credibility's sake, to step up and do the right thing and point that out to the court's attention. Luckily, it worked out that the analysis is out there and it was adopted by the Court of Appeals, and we're all good. So you can still cite that case for the things that it stands for. But it's an example of me having to do the right thing, even when it was very difficult for me to do that. Beware of your cognitive biases. You have them. I have them. We all have them. There are several varieties of cognitive bias, and they're things that you need to be aware of as an advocate making your argument. At the podium, I see my role as to being an advocate rather than an activist. You have things that you believe in very strongly, and you're trying to achieve a certain result, but you are trying to do it in a way that is not showing a strong bias, not showing a strong personal argument, because it's not about you. It's not a personal thing. You're making a legal argument and you're trying to be persuasive. The court is looking for the legally correct answer. If the court sees that you are biased, if they see that you have a very strong personal stake in the matter, it could be that they will take your argument as less credible. They're going to be more skeptical if they think that you really have you're not coming at this solely as an advocate, but as an activist. So it's important to recognize the biases that we have and to kind of check them and be aware of them before we write a brief, before we go to oral argument. The first type of cognitive bias that I wanted to mention is the bias blind spot. And we tend to think we're less biased than other people. We overestimate our impartiality. So it's just something to be aware of, that it's a thing that humans do. And so you have to know where you're coming from. You have to be able to kind of see yourself the way that others see you. It's a very difficult thing to do. And it's especially hard when you're talking about something, you're making an argument about something you care deeply about. As we all do about animals. Everyone who's watching this cares very deeply about animals. So if you're making an argument that is going to the core of those beliefs, it's especially important to step back and kind of temper the way that you come across, I think, and recognize those potential biases in the way that you're presenting to the court. I would regularly see attorneys who represented their clients at the trial level lose and then represent their clients at the appellate level. And those lawyers were almost always not very good. I think that because they would get snippy, they would get defensive, it would become personal for them. And so it's taking that personal piece out and trying to be as not dispassionate. I mean, it's good to be a passionate advocate, but not personal. The other type of bias to be aware of is called consensus bias. And there's something called the false consensus effect. The false consensus effect is a phenomenon where people tend to overestimate the popularity of their own beliefs and preferences. When we're working in an organization, if you're working in an organization of people who have very strong opinions that are the same as yours, like I do with the Animal Legal Defense Fund, like some of the others of you might do for other organizations, it's a great source of support, and it's a great way to brainstorm. It's also makes it difficult sometimes to see the weaknesses, to see the if you assume that everyone sees things the way that you do, and you're working with people who all see things the way you do, it's just especially important to find someone who you can run your argument by, who doesn't share those beliefs, someone who is coming at it from a different perspective, because judges aren't going to share your beliefs either. Some of them will, some of them won't, but you're not necessarily going to be coming from the same set of underlying assumptions. So something that I used to do is run my arguments past the most skeptical non-animal person in the office, someone who, he didn't have companion animals. He just, was kind of ambivalent about them. And if I could get him on board, if I could convince him that I was making a solid argument, that I knew that I was in a good position to make the argument before the court. All of the things that I talked about with respect to attorneys and respect to people, those biases, judges have those same biases. There's nothing magical about the robe that when you put on that takes away bias, that makes someone impartial. I mean, they're impartial in that they don't have a stake in what the case is before them, but that doesn't mean that they don't have internal biases and perspectives that are going to affect the way that they see things and affect the way that they hear your argument. It's safe to assume that they are not necessarily going to share your beliefs, and you should assume that they don't, because that makes your argument stronger. If you're able to convince someone who doesn't share your beliefs, you're going to be in a better position. So judges are people, and people develop biases based on their life experiences. Therefore, judges have biases. Judges are people do this, so judges have these biases. Just like with practitioners, the best ones keep those biases in check. They're aware of them. They consider that when they're making their decisions. But it's just important to recognize that they may not believe what you believe, and it'll make your argument better to assume that they don't. Whenever you have the opportunity to make a decision about which case to bring, and I recognize that people in a lot of areas don't have that opportunity. The cases are given to you. If you're a defense attorney, the case is the case. But prosecutors have this luxury to some degree. Civil practitioners have this luxury to some degree. Choose your cases wisely. Bad facts make bad law. It's absolutely true. It's something that you hear a lot, but I've seen it in action enough times. Cases that are on the margins factually are not going to be the cases where the court is going to be willing to make a big leap or going to go out on a limb for a legal position if it's at all questionable. So consider the facts. You consider the choice of claims that you're making. Depends on your jurisdiction. You have to know your jurisdiction and know whether it's an area or a court that is going to be receptive to the type of claim or argument that you're making. It's especially important with animal law because it is so relatively new. In animal law cases, it's especially important because it's a new and developing area of law. Courts are going to be more likely to look at what other jurisdictions are doing than they might otherwise be. So I think you have to consider that the case that you're bringing, if you end up with adverse case law, that analysis could spread to other jurisdictions dealing with the same issue and who are looking for guidance for good or ill. when I was an attorney with the state, we would have to consider this when we were looking at states appeals, where if we would have a court issue an opinion in a county that was adverse, that we didn't like, and the practitioners in that county were unhappy about, but we had to think about, okay, what's going to happen if this becomes law for the entire state? And I think as an animal law practitioner, you have to think that way to some degree as well. But sometimes the facts are so egregious that even a loss in court could potentially be beneficial because it could be the basis for legislative change. So there's no clear-cut answers. It's just particularly important to be strategic when you're an animal law practitioner. It's also important to embrace incremental change. I think there are two types of change. There's step change, which is kind of a sea change, a dramatic change that's sudden, and that there are times that happens. There are certainly times if the moment is right, but incremental change is far more common, especially in the law. You're talking about judges tend to be conservative in making and they should be when they're making changes to the law. You need to think about the big picture. You need to think about how this is going to play out in the long term. So I think they tend to think small. And if you're thinking too big, the court might not be willing to go along with you. You might be taking too big of a bite for the court that they might not be willing to go along with. They generally don't want to make sea changes in the law. And it's important to identify the limiting principle in your position, because the court will be looking for one. I was often, as an advocate, asked by the court, what would the opinion look like? If we accepted your position, what would the opinion have to say? Considering that this is going to be viewed by, cases down the road, that we're giving guidance to practitioners, and courts, what would it say? So you have to identify that limiting principle. If you don't, the court is more likely to come up with one that you don't like, because they will be looking for one. If all else fails and you bring a case, you lose it and you get a bad opinion, there's always the possibility of a legislative fix. That it's not all is not lost, and one bad opinion isn't the end of the world. But think small, and we will get there eventually. All you have to do is look back over the past few years of animal law and see how far we've come in a fairly short period of time, and it's generally through small changes. So this is my last slide, and I just want to emphasize how important it is to be professional while still being yourself. I might initially said be professional but be yourself, but I think it's more accurate to say be professional and be yourself. It's okay to have a personality. It's okay to let your style come through. It's okay to smile. It's okay to occasionally, and this can be risky, to make jokes with the court. You have to read the room, and you have to be familiar with the court and follow their cues. But it's okay to have a personality and to show it. It's always important to aim for clarity. You're aiming for clarity. You're not trying to use $5 words. You're trying to be clear and write. Your brief should truly be brief. They read a lot. They appreciate that when they see it. And by being clear and direct, it makes you look confident. I mean, if you're hiding behind kind of ornate writing, it can make you look insecure, and it's not as persuasive to the court. And at argument, you definitely don't need to use all of your time, and the court will appreciate it if you don't. They're busy. They're very busy, and they appreciate if you can get your opinion or your position across as briefly as possible. They always appreciate it. The bottom line is that the more authentic you come across, the more likely you are to make a human connection with the court. And that's good both for your argument, your chances of success, and for your job satisfaction. I think it's just, if you're making a human connection with the court, it's just better all around. The article that I submitted along with my materials, I didn't write the article, but it talks a lot about that empathic human connection and its importance in persuasion. So that's my presentation, and I appreciate very much for the opportunity, and I hope to meet you all sometime in the near future. Thank you.
Thank you so much, everyone, for those presentations. So now I'm joined live with Judges Romero and Raisin to answer all of your questions. Looks like the first one up is, what are some challenges that you or other judges may see when sentencing an individual convicted of animal cruelty or abuse? The sentencing guidelines don't seem to provide much to protect animals and appropriately punish their abusers, and I was wondering your thoughts on this.
I'd be happy to take a crack at that. I think in the juvenile context, when a youth is charged with some form of animal cruelty, as already noted in my slides, I think the bigger picture needs to be looked at. Certainly what the allegations may be are horrendous and conscionable, yet this is a child who should not be thrown away. They're a member of a family, they're a member of society now, and hopefully will be better situated in the future. So as I mentioned earlier, a screening tool, if one is available, to determine whether it's something that is beneath the surface and is not actually what we're seeing, or is more than what we're seeing, an assessment if necessary, and then an evaluation to inform and provide us information about what kind of treatment and therapy may be useful for that child. Remembering, as we do in the juvenile justice world, that kids are not little adults in kid clothing. They're still salvageable. Most of them are, and I've not met any that are not.
Sorry about that. My cat Penny was trying to walk on my keyboard and was about to close out my screen. Judge Raisin, did you want to add anything to that?
Well, I think I've expressed my views that with justice, reinvestment, and so forth, typically a first-time offender is going to receive probation. And my goal is to modify their behavior. It's not so much about meting out punishment that's appropriate. After all, I recognize the defendant in a hoarding case has caused horrendous suffering. I may not consider what I'm doing to be punishment, but I can tell you the defendants do, being subjected to the conditions I impose. And it very much depends upon your point of view. Is this to try to prevent future behavior, or simply to punish somebody, get the pound of flesh for past deeds? And I think our approach in problem-solving courts is to modify future behavior.
And certainly, I can say our work at Animal Legal Defense Fund is focused on victims and preventing harm to future victims. So a big part of what we advocate in sentencing is rehabilitation for offenders, so that we can reduce those rates of recidivism. Let's see, another question. What kind of training for the public is available to recognize abuse of animals? And it looks like that person was thinking specifically of animals other than pets or companion animals, but animals classified as livestock, for example, horses. So what I would say to that is you don't need to necessarily know whether what you're witnessing violates the criminal animal cruelty code. That's for law enforcement officers and humane investigators to determine. So if you see something that you think is concerning, if you see an animal that you believe to be in distress, always report that.
It's different depending on where you are in this great country of ours. If you're in a rural arena, and you're more likely to be seeing large animals than the household pets. Your helping cat, for example, those are the ones that I most frequently see, are the small animals. But having grown up in the country and on a farm, thinking back to some of the things that I saw adults doing to cows, to horses, to sheep, mistreating them physically, knowing what I know now, I think I would be compelled to say something. The old adage recently, if you see something, say something. You may not be the one who has the answer, but others might. So don't sit on your hands and just look the other way.
I think animal control officers play a big role in educating people.
Yeah.
appropriate treatment of animals.
And you can also go to the National Link Coalition website. There is a feature on there too. This is where do I report? So any county that you're in the United States, they'll direct you to the correct reporting authority. See, another question says, have there been any federal programs created to help address the connection between domestic violence and pet safety? In Minnesota, there's a nonprofit called Minnesota Association for Pets in Crisis, which helps women escape TV situations to shelters that are pet friendly. I'm wondering if there are similar programs happening at the federal level.
Seems to me that many of the federal programs are very broad and policy focused rather than actually in the trenches doing things. Communities where folks get together and collaborate to identify the issue and come up with a solution seems to be much more productive. Colorado comes to mind as a state that has taken the bull by the horns, no pun intended, and actually gotten a lot of legislation enacted that focuses on dealing with animal cruelty in all contexts: elder abuse, domestic violence, child abuse and neglect, juvenile justice, and I think some of the information I provided as other resources makes reference to some of the Colorado statutes.
Yeah, and there recently was federal legislation that specifically looks at that issue. It ordered that all states recognize animals being involved or being included in protection orders when enforced across state lines. And it also provides funding for shelters to convert to become pet friendly so that domestic violence victims can seek help. And there's also some resources like Safe Havens through the Animal Welfare Institute or Red Rover that have networks that show where pet-friendly shelters are in your area. So there are definitely efforts going on at the national level. Let's see, one other question says, I struggle with the hypocrisy of criminalizing cockfighting, sometimes as a backdoor way to target drug or other crimes unrelated to animal cruelty, when similar abuses on far more massive scale in the factory farming industry are entirely legal. How, if at all, does the judiciary make sense of this kind of dissonance, for example, at sentencing?
Well, first of all, it's my understanding that the things that are done to the animals to have them engage in cockfighting actually is abusive, but I'm no expert on that.
Absolutely.
The thing is, judges have to take the cases as they come. We don't write the statutes. We don't, it's really not appropriate if you've got an animal abuse case, a cockfighting case, and the defendant is convicted, to say to yourself, well, I'm not going to take this seriously, or this is really a hypocritical situation because things are much, much worse on factory farms. And, you know, many, many more animals are suffering on factory farms. That may be the case, but it's incumbent on judges to deal with the defendants in front of us and sentence them based upon the statutes and sentencing guidelines and who that person is. I mean, that's my view of the judicial function.
I think that certainly in the juvenile and family law context, since judges in that arena are already viewed as social workers anyway, you know, we can do things outside of the court, in the community, to bring folks together. We're not the ones who need to make the decisions, but we're the conveners to identify a problem. And as a judge, I may not, you know, likely I'm not able to get in the trenches and do things because that kind of case may come before me. But that doesn't mean that I can't function as a convener and provide a forum, whether it's in court after hours or outside of the court at a community center, to bring folks who are concerned together to formulate an action plan, if you will.
Yeah, and I would also just add that even if there are gaps that we would not like to see in the law protecting certain animals, that doesn't mean that we should, reduce the bar to the lowest common denominator. We should be applying the laws and enforcing them to the best of our ability in all of our roles in order to protect as many animals as possible. And it's unfortunate that the law does fail some classes of animals in that way, but I agree with the judges that is a fight for the policymakers. All right. Well, we are out of time. Thank you both so much for joining us.